President. Our today's man of the match, Mr. Govindaraju, is here with us, and all past presidents, directors, and all other members.
Basically, yes, they have shared the link also. So we have joined through link, Zoom.
ఏదో అప్పుడు అనుకుని చేసాము ఏదో గుడి కట్టాలా అది ఎంత పెద్ద పని అనుకుంటే
Sir, in our industry, that is the major part what we have to see here. Of course,
speaker
to leave the job within 2 days as per the code. It is one of the point which is very tough. Then bringing down 50% of wages to basic is also a very tough job. We will be losing heavily in all other payments like gratuity, etc. Other than that, not allowing contract employees on the core activities. That is also big issues. This is the major issues which employer are going to face. Then I will talk a word about ministerial leave also. Rituchakರದ ರಜೆ ಅಂತ ನಾನು ಇದನ್ನು ನಮ್ಮ ಮಿನಿಸ್ಟರ್ಗೂ ಹೇಳಿದ್ದೆ. I told our state minister, we already have around 79 to 80 holidays in a year. 52 weekly off, 18 EL, 12 sick leave, then 10 festival holidays, totally 80 we have out of 360. That means at present itself, for every 4 working days, we are giving 1 leave. That means 80 is 1/4 of 365 days. And in IT companies, they give another 52 days as a second, every Saturday holiday. So every 3 working days, they are giving 1 holiday. They work only 200 days out of other, all things are holidays only. Then further, we are giving 365 days in a service for maternity, 2 maternity leaves we are giving for women. That comes 365 days for 30 years of service. Each year will calculate as 12 days per year, per annum we are supposed to give. We are already giving that. Still, this is a very, very sensitive issue, very competitive issue, and it is the opportunity for other states nearby, like Telangana, Andhra, Tamil Nadu, to attract all new investors. It will give a scope for them with this new, not required at the moment. That was our opinion, which our consultant will have to tell about that. Then third, the point is discussion is POSH committee. Of course, there is no doubt all of us have to join hands to make that, to implement that, but only whether it is required. If I have a 25 people, only men in my factory, whether that is required. If I have 25 men, that is in such cases we have to discuss, we have to take it forward. Otherwise, it is genuine, we can enforce it everywhere. That was my point. But anyhow, it is, the form is for you. First, Mr. Govindaraju will explain what is what, and definitely you can come out with your points. If anybody did not got the opportunity, you can mail us also, madam. They can mail us also afterwards. Then we'll give the reply. And what you wanted from FKCs also, you can tell about how to go about, what all representation we have to mention also, you can tell. Thank you for coming here, attending, and increase your knowledge. Many of people have the knowledge, but it is better to learn still more. It is opportunity. Thank you.
And also a very warm welcome to all those who have joined online. It's nice to see you all. We regret the delay in sharing the link with you. We had a technical glitch here, but thank you for joining, and we will go ahead with the session. Our advisor, Mr. Thallam Venkatesh, has joined online. Sir, if you can, unmute yourself and speak so that, we have your thoughts, and then we go ahead with our expert, Govindaraju, speak. Yes.
Good evening to everybody. I'm sorry I'm not able to join physically to be participating in this meeting. But anyway, as told by Mr. Rao, it is a very sensitive subject. But the reality is that whether they, especially the MSME sector, will be able to take on these amendments and implement it. Second thing will be immediate follow-up will be that you will stop recruiting eligible female workers or staff, because it's going to be an additional burden on the existing system itself. So let us hear about from the specialists, and then we can see what can be done. Thank you very much for giving me the opportunity.
Thank you, sir. May I now request our guest, Mr. Govindaraju, consultant, to address the members.
Yes, sir.
Good evening, everyone. Yeah, thank you, madam, and thank you all the dignitaries for the opportunity. As all of you know, on 21st November 2025, all the labor codes have been enforced, especially the IR code, OSH and WC code, code on wages, and the Social Security code 2020. And you may also have a confusion that whether in absence of the rules, whether provisions have to be implemented or not. So if you look at the central government, so far the rules have not been finalized. The story is the rules are framed, drafts were announced at the time of when the codes were enacted, but the draft rules have not been finalized. Now the ministry is saying that you must have seen all in the news and social media that they will re-announce again. The drafts will be re-announced, and they will take 45 days for getting objections and comments. Once they know all the objections and comments, then they will notify the final rules. So that is not only that, since the labor matter is in the concurrent list of the constitution, both state government and central government have the power to take care of the rules part of it. So also now if the state governments do not frame the rules or they make it delay, should we implement is also the question. But if you look at now, all the 4 codes are in force today. Whatever the provisions which do not need procedural rules, so that have to be enforced. There is no other go. But whatever the provisions which need rules or the procedure, then that can wait until the notification of the final rules. Now, if you look at what is common to all codes, now all the 4 labor codes, there are few things which are very common. If you look at the first one is harmonization of definitions. So earlier what used to happen is these all 4 labor codes actually subsumed 29 legislations pertaining to all these chapters matters. And if you look at each statute, they had different definitions. For example, wage is not the same for ESI, wage is not same for the PF, and wage is not same for the employees compensation. So if you look at now, you have common definitions including wage, employee, worker, and also the appropriate government, so that the statute and the government wants to ensure that there is no much confusion on the definitions. So because these definitions are required for understanding the codes. So if you go into the code, if you do not know these definitions properly, then you will not be able to understand. So therefore, the codes have harmonized all the definitions so that it is applicable to each factor of the code. Now the next one is inspection to facilitation. So today the codes want to achieve that they don't want to have an inspection culture. So they want to have a facilitation. That means the inspectors which are already there in the system, they will facilitate the industries. So that is what is the spirit of the statute. Whether that, how far they will be able to achieve, that is a questionable still, but the courts talks about facilitation and how they will make it reality, which we have to see in the future. Now, possibility of getting away from the jurisdiction based inspectors. So this is what you are seeing today. Each and every jurisdiction, there is a nominated or designated inspectors, but the courts have different view. They are talking about, no, there will not be any one person as an inspector. So they will actually randomized selection will happen from the web system. And also whenever they would like to do an inspection, they will select the industries from the web-based system. So that is what the codes are talking about it. But the inspection system has to be drafted by the central government for which are the industries under the central government as an appropriate government. And the state government, whoever industries are under the state government, so they have to actually make an inspection system to give an effect to this system. Now the next one is decriminalization of offenses. So this is nothing but if you look at revenue laws today, there's something called composition and compounding of offenses. So if I talk about in general sense, just like that, you just give a money and get out of from the prosecution. So whatever the money is fixed for each offense, you pay that money and then you will not be prosecuted. So that has come into the all the four courts. So many provisions have been done with decriminalization of offenses. That means the employer is not required to get prosecuted if he go for a composition or compounding of offenses. Not all the offenses have been compounded, but there are plenty of offenses have been put to composition or compounding of offenses. Now the courts, all the four courts would like to achieve single license and single returns. Today, if you see, each legislations require its own legislation. You talk about PF, ESI, factory, or contract labor. So you need many licenses, and also each statute talks about different returns. Now the code would like to achieve this single return and single license concept, and all the four codes, if you look at, they have covered both organized and unorganized sector, and also they have also understood the new employment types. For example, gig workers or platform workers. Gig workers are nothing but they use the platform to access the resources and then they support. And the platform workers is similar non-traditional employment types. Yeah. So they also cover, and courts also would like to achieve certain social security measures for these people. And the limitation period is harmonized. For example, for the claim or the prosecution, each statute talks about different limitation period from 6 months to 3 years. Now the code has actually harmonized this limitation period, one limitation period, which is around 2 to 3 years. It depends on the code, but under the code on wages, it is 3 years limitation period has been put. And also, if you look at ESI and PF provision, today ESI has got a limitation period of 5 years. If the inspector comes, they can only go back last 5 years or the previous 5 years. But in the PF, there is no such thing. Under the PF and Miscellaneous Provisions Act 1952, there is no such limitation. But the Social Security Code now has brought this limitation applicable for both ESI, PF, and any other social security scheme which gets announced into the Social Security Code. So that is the beauty of these codes. And ಇಲ್ಲಪ್ಪ ಅದೇ ಹಿಂದೆ ಹೋಗಿಲ್ಲ. There are few things which are not so good also, as Mr. PC Rao talked about it. There are many things which are not good, but there are certain things are good for the employers and there are certain things good for the employees. The courts have actually tried to balance the rights of employees and employers, but how far they were able to balance it, that is also questionable and subject to debate. And if you look at all these four codes, each every code applies to everyone. Even if you have 5 employees or 10 employees, it doesn't matter. For example, IR code, there is no threshold. Code on wages, there is no threshold. Only in code on social security and OSH code, there are thresholds. But OSH code, generally, if you have 10 and above people, the OSH code is applicable. You have to comply all the provisions. But in terms of social security code, depending on the scheme, for example, ESI, PF, there are still whatever the old thresholds are there, they are continued. But they have done some changes, which I will also brief you. And if you talk about other harmonization or common things, one is graded penalty. That means for small punishment, small penalty and bigger punishment, bigger penalty, like that. They have graded penalty. Another disadvantage, I would say, is the judicial power in the hands of executive or officers of the appropriate government. So this is nothing but, if there is any claim or if there is any case, then normally you will go to where you will go. You will go to court. So so you will go to court, but the court, what the courts are talking about is, in order to reduce the burden of the courts, now certain offences, inquiry and charging is with the judicial power now. So they will decide the case. So this is also in a way advantage, and this is also in a way disadvantage. People who are not so sincere, they may not be good for the employers and the others, but people who are very sincere, they may do a good job in the judicial power in the hands of executive. And because these 29 legislations are subsumed, so this multiplicity is reduced. And another important parameter of the provision which I would say it's available is, before prosecution, the inspector is required to give an opportunity to set right the non-compliance. So without that, he cannot proceed for prosecution. So these are which are the, yeah, it is there. Yeah, prosecution is there. You can get away with the money as well. Okay, you can get away with the money. Yeah, get away with the money, but also the inspector is required to give an opportunity before prosecution. And also, when is this compounding, it is also kind of a prosecution. Before getting into prosecution, you just give the money and get away from the offenses. So that is what is available. I would say these are the common things. Next slide, Appa. So if you look at now social media, there are a lot of things which I read which are not in line with the codes. I would say these are the myths. So if you look at the first one is, you must be hearing that basic salary 50% of minimum CTC. In a way it is right, but it is not entirely right. The code is not talking about basic should be 50%. What the code is talking about, the code has made the wage components into two factors, or two segregation, two parts. That is called, one is inclusion, the other one is exclusion. Whatever we call it as inclusion, that should be treated for all the purpose of the code, including PF, ESI, gratuity, all those things. So what is inclusion is clearly given, and whatever is okay, na? So whatever is not exclusion, everything is inclusion. So in the exclusion, there are 11 components are excluded, including your house rent allowance, conveyance, and overtime allowance. All those things are excluded, including bonus, gratuity, everything. There are 11 exclusions. If any amount or component is not into the exclusion, then that is inclusion. So whatever it is called inclusion, then that should be treated as wages for the purpose of the code. Another important, confusing, or I would say difficult to understand is, there is one proviso which talks about, if the exclusion is more than 50% of our total remuneration, that excess should be added back to the wages. So that is why code is trying to balance that your 50% should be wages for the purpose of the code, and 50% is not for the purpose of the code. So they would like to ensure that 50% is treated for including all your social security measures. That is what is the code is talking about. If you say basic salary should be 50%, the layman may agree, but I don't agree. It is inclusion, exclusion. Whatever the components you say, if it is not exclusion, whatever the component you pay, that could be inclusion. So the inclusion part should be treated as wages for the purpose of the code. That is an understanding. Now, gratuity after 1 year. Earlier it was 5 years. See, this is in the social media, you say everybody for working for 1 year you will get gratuity. That is not entirely, that is not correct at all. What the code talks about is, if you are a regular employee, the gratuity condition remains same. There is no change. So you work for 5 years and get it. But suppose if you hire fixed term employees, so fixed term employees should get a gratuity on a pro rata basis. Contract, you put a contract agreement for 3 years or 4 years. You have to make a differentiation between contract employees and fixed term employees. The contract employees, if you outsource someone through third party, or you have a mediator, so that is contract employee, but you take directly on a contract period or an agreement period, so that is called fixed term. So such people have to be given gratuity on a pro rata basis. So that is what talks about it. And also people talk about even fixed term employees have to be given only 1 year after 1 year gratuity. But that is also not entirely correct, because there is a conflict between IR code and social security code. If you look at IR code, gratuity should be payable after 1 year. It straight away talks about it in the fixed term employee definition. But social security code, which is the code for gratuity, talks about pro rata gratuity. So therefore that understanding is also in the social media is very incorrect. And exit dues within 2 days. So what your social media posts are talking about is, so whenever employee leaves, you have to pay all the dues within 2 days. That is also not entirely correct, because what the code on wages, it's only coming from the code on wages 2019, it talks about the wages, the pending wages have to be given within 2 days. But how much it is practicable is a questionable, because if he has got any liabilities or payables to the company, how will you settle it? That is one point we should, I mean, the chamber has to take it up with the government and ask for an amendment, because the code, whoever has drafted the code, they may not have the industry exposure. I don't think they didn't call us also. So we, yeah, we were not invited for that. So looks to be the department officials and the IAS officials must have drafted this code. So therefore they don't understand what is the realities of it. So therefore it talks about wages. Even wages, you cannot settle it within 2 days. If he has got any loan advances or other dues, assets with him, laptop, all those things. So that is why it is practically not possible to do it. Then the chamber, I would request to take it up with the government on this. Reskilling wages, they talk about 15 days for every year. It is not so. In case of any retrenchment, you are terminating or retrenching any person because of the business slowdown, you give another 15 days additional wages as a reskilling wages, and that too you give it to the government. Government will pass it on to the workmen. So that is the understanding. But I don't know why they are routing through government. If the government would have asked, okay, he should get another 15 days to reskill him, so pay it directly. The government didn't do it. The government takes the money and transfer it. I don't see any meaning there in that. That is what is the rules are talking about it. So I'm not trying to explain my interpretation, the rules which are talking about it. And cannot use contract labor for core activities. Now if you look at as on today, the contract labor is permitted anywhere, everywhere. People have a wrong notion that the contract labor should not be used in perennial and regular nature of works, but that is an incorrect understanding of law, because there are riders for that. If there is no prohibition from the government, and if you are not violating the licensing and registration provisions, and also you are not directly supervising, if the contract is not sham and bogus, then you are free to hire contract labor for any work of the industry. So this is very clear. Judiciary has made it very clear on this. The Supreme Court has made very clear on this. So that is the current status of law. Only the contract labor is prohibited under section 10 of CLRA 1970 when the government prohibits specifically that contract labor. However, no government have actually prohibited, only where there are very stray cases where they have prohibited in canteen and some other works in the past. But the government has not really prohibited any contract labor so far. So that is the status of law today. But now the industrial in the OSH and WC code, especially section 57 of the code is directly talking about that you cannot use contract labor in core activities. So core activities is nothing but for which the industry is set up, including essential and necessary activities for that industry. So everything is treated as core activities. You may say that I employ a contract labor for support jobs in the shop floor, like helping. I would say that is also core activity, because as long as it is connected to your process and product, that could be called as core activity. So therefore it is straight away prohibited. But there are certain exceptions. For example, if it is only for limited period or its full-time work is not there, in such activities, full-time, for example, full-time means 8 hours 365 days. So if it is not based on the process, if it is not available or the work can be finished within not full-time, in that way you can still engage contract labor for core activities. That is possible. Or if the activity is intermittent, it is not regular, there also you can use contract labor. There is another exception which is called as if you have a high demand or sudden demand, it comes. It could be seasonal. In that case, for 6 months, 7 months, you can still engage the contract labor. And also one interpretation, let me give you here. The contract labor, if you outsource as an activity, for example, you don't employ the contract labor, but I would like to give entire activity to someone to manage it. In that case, what happens, this is not the supply of contract labor, it's a business to business. Like for example, there are various specialist industries including maintenance and other things, also the freight forwarding. They take the job from end to end. For example, once the product, subcontracting, okay, once the product comes from your machine, they take it and end until dispatch, they take care of that entire activity. So in my view, that activity may not cover in the OSH and WC code. That is one of the opportunity which you can use it. But if it is only contract labor supply, this section 57 comes into picture, and other than the exceptions, you will not be able to engage. But non-core activities, for example, security, housekeeping, gardening, canteen, loading, unloading, everywhere, contract labor is possible. So that is possible. So next up. Yeah. So work from home officially recognized. If you see the social media, so they have made it very big that work from home for women employees is officially recognized. But I would say this is not new. If you look at Maternity Benefit Act 1961, that is very much is there. And also that is not obligatory on the part of the employer. If it is possible, feasible, and then only you can agree to give, for example, if it is a workman working on the machine, what will you do with the work from home? What will you do with that? Correct? No. So that is an incorrect understanding of law, and social media is all bluffing all these things. So I thought of clarifying it to all of you. Next, Madapa. Okay, so let me come to IR code. It's very important also in terms of employment and other things. The first one is a very big step has taken by the government, that no permission requirement to close down your industry, or if you want to lay off, and even retrenchment, if you have less than 300 workers. But today, under Industrial Dispute Act, Chapter 5 and 5B talks about layoff, retrenchment, and closure. If it is mine, plantation, and factory, special chapter 5B applies. For all other industries, there is no requirement of government permission. Only for mine, plantation, and factory, there is a requirement of permission from the government before you close down. And also you lay off or retrenchment, permission is required if you have 100 and above workers. Now that threshold has been pushed to 300 workers. So that is a very good step. You don't have to go to government for permission, and then you can take a call. So you know that if you go to government, you don't easily get the permission, and I have hardly seen any industry has taken the permission, has given the permission. So that's not possible. Yeah. And the second one is, if you look at Industrial Employment Standing Orders Act 1946, so this talks about terms of employment. We call it a standing orders. If you have 50 or more employees today, you are required to go for a standing order certification. Even though law talks about 100 employees, but the Karnataka government has made it 50 and above. So if you have 50 and above workers, then you have to get your standing order certified, and that will become the law for your establishment. But that threshold has been now pushed to 300 and above workers. And this means the statutory terms of employment will have not impact on you. You can decide the terms of employment for your employees by way of your service rules or your appointment letter holds good. Okay, that is one. But one thing is, if you already have certified standing orders, this will not help. Okay, the standing order has already been certified to you. That is the law. So you can't change that. But the new industries, those who have not have the certified standing order, so that benefits these people. And another game changer in Indian industry is fixed term employment. This is, if you look at current judicial trend, you cannot employ fixed term employees in permanent and perennial and regular nature of jobs. If you are able to give regular jobs, then the judiciary doesn't allow that you can employ fixed term employees. The fixed term employees are legally allowed, though your standing orders modification and everything is done. But if you are employing on a permanent jobs, or where the jobs are there for longer time, so that time you cannot employ fixed term employees. Judiciary has not said okay for that. So you can employ fixed term employees only where the job has an end date. Any job you talk about it, if you say that is an end date, then you can employ fixed term employees. Otherwise, it's no go. But now in the IR code 2020, it is an express provision It's very clearly defined. Earlier, it was not an express provision, and it was only Section 2O of Industrial Dispute Act. It was implied contract was there, implied understanding was there. But now the code has given very clear understanding, not only defining very specific to fixed term employment where you can engage people on a fixed term basis, and then once that period is lapsed or expired, you don't have to continue them, so you could just disengage. But also let me tell you that once you have fixed term employees, if you have a renewal class, that is not called as fixed term employees, that will be called as renewable contract. So therefore, don't have any renewal period in that. And if at all you want to engage further period, you may have to take some time and then engage. Engage. So that is what is required. Don't engage on a renewable contract. Renewable contract is not fixed term employment. So that is one important change. Not only that, in the retrenchment definition under IR code, the fixed term employment where if the employment gets terminated after the elapse of the contract, it is not called as retrenchment. So therefore the law is very clear now. What I would say is if the code has closed one door, it has opened another door. Okay, so that is what I would say, because fixed term is open, the contract labor is closed. But only thing is going ahead, the judiciary has to understand the spirit of this code, and judiciary has to support the employers. If the judiciary is not supporting the employers, then definitely it is one-sided. So I don't say that I don't conclude that it is one-sided, because while framing the code, the lawmakers would have understand that, okay, let us close the door for contract labor and let us open fixed term employees. So that is the spirit of the code. But now let's see how the courts will react to it. Now the next one is, in the IR code, going on strike is literally made impossible. I would say how. If you look at now under Industrial Dispute Act 1947, once the strike notice is issued, it is only in case of public utility services, then the conciliation is mandatory. Once the conciliation is initiated, then the strike is prohibited. In case of private establishment, giving strike notice is not mandatory unless it is available in your standing orders or in your settlement or any other document which mandates the employees in the union. So then only it is mandatory. Otherwise, they can without the notice also they can go on strike. That is possible. And also during the conciliation with the conciliation officer, and also until the government refers the matter to the labor court, the courts, they take up the matter. Up to that time, the strike is not prohibited in a private establishment. Okay, they can go on strike even the conciliation is in progress. So some people have misunderstanding that if the conciliation is in progress, before the conciliation officer, the strike is prohibited. There is nothing in the Industrial Dispute Act. So before the conciliation officer, he has no power to prohibit the strike. That is possible. Okay, so therefore they can still go on strike. So now what has been made is, whatever the conditions which are applicable to public utility services, now they have been made to every establishment. So that means before going on strike, any worker or a trade union, 14 days, minimum 14 days notice is necessary, and the outer limit is 60 days. They can't go strike within 14 days, and within 60 days they have to go for strike if at all they want to go. If 60 days elapsed, they have to give a fresh notice. So that is what is the understanding of the law. And once the strike notice is issued, then the conciliation initiation is mandatory. Once the conciliation is done within 14 days, then the strike is prohibited even before conciliation officer. So this is an excellent closure, intelligent closure, I would say. But for the employer is, if you want to go on lockout, the condition is same. So therefore it is a win-win situation. It's a two-way situation. And introduction of limitation to industrial dispute, if you look at today industrial jurisprudence, limitation to industrial dispute is unknown. Okay, even if after 4 years, 5 years, 10 years, it is possible that worker can take up the matter before the court or through the conciliation. So there is no limitation period. But good thing is now the IR code has brought a limitation of 2 years for all industrial disputes. So if there is a claim from the worker, it has to be taken before the authority within 2 years. So that is what has come. And it's especially these things are very important for employers. Now, concept of negotiating council has neutralized the problems created by multiple unions. Now, if you look at if you have a single union, less problems. But if you have 3-4 unions, then the politics will kill your industry. The union politics will kill your industry. But in order to neutralize the situation, if there are multiple units, or the unions, what the code is talking about it, any union which has got 51% and above membership, that will be the sole bargaining agent for the industry. But no one has got 51%, then every 20% they take one membership and then constitute a negotiating council. That recognition will be valid for 3 years. So until 3 years, there is no change is going to happen. So therefore, you can rest assured that if it is a single union or negotiating council, at least for 3 years, you will have same negotiating council. There will not be any change. So once the settlement is done, that is going to be there for 3 years. You will not have any change. Even the union changes, membership changes, there is no impact on the industries. So that is what is talking about it. And a deemed certification of standing orders. Now today what is happening is you have to go to the certifying officer, submit your draft 5 copies, and then take your workers and also negotiate and debate there and get it certified. But now the standing orders, model standing orders are drafted by central government. The power is not with the state government now, it is with the central government. Yeah, they have already notified the draft model standing orders. Suppose if once the standing orders made permanent or regular, if any employer would like to adapt the same, you don't have to get it certified. You just send a letter to the government that I'm adapting the model standing orders. Then there's no certification is required. And notice of change, which is section 9A of Industrial Dispute Act, that is very important, because if you want to change any terms and conditions or which is existing, you have to give a 21 days notice to the workers. And it's not so easy also, because the moment you give a notice, if the worker is, if union is okay, they will accept it. Normally they won't accept it. They will go to the conciliation. Once the conciliation goes, you can't do anything. That becomes stagnant there. So until the court decides that. So, but in case of any shift change or shift working during emergent situation, there is no notice of change is required, and only consultation with the grievance redressal committees is only necessary. And ghost law, of course, is very bad for the industry. So far, we did not have any definition in the Industrial Dispute Act or the industrial jurisprudence. Now the ghost law has been very defined and treated as unfair labor practice. So that has come into the code. Now also, when you retrench someone, you are required to rehire whenever there are vacancies arises. For that, there was no limitation. Now what the code is talking about is employer is not bound to rehire retrenched workers if vacancies arise beyond 1 year. Okay, only within 1 year, if the vacancies arise, then only you have to rehire. But after 1 year, if these are arises, you don't have to rehire them. But today is not the so situation. So these are the very good measures under the IR Code 2020. Next, Ogappa. Now let's look at what they have gained, workers have gained. Now the first one is today, if any union occurs in your industry, you don't have to recognize the union. That is a law. There is no permanent recognition, or the mandatory recognition is available. Yeah, you can, they will fight with you. So let them go on fighting somewhere. You may succeed in neutralizing the union, or they may succeed to convince you for acceptance. That is possible, and they will continue their pursuit of dispute. Okay, but that is the situation, except in Rajasthan and Madhya Pradesh and Maharashtra, there is no mandatory recognition of trade union. Okay, even in Karnataka, there is no mandatory recognition of trade union, but the code talks about mandatory recognition of trade unions. And if I have told you already, if there are multiple unions, negotiating councils have to be constituted. The another one, what they have gained, which is not so good for employer, is possibility to litigate individual disputes other than dismissal or termination. If it is termination or dismissal, that is definitely a dispute which goes to the court. They have a possibility. But if not this kind of disputes, like for example promotion or increment, something like that, now they have a possibility to litigate through the grievance redressal committee, and after the grievance redressal committee, they can take it to the court also. Okay, earlier any individual dispute other than retrenchment or dismissal, if it is not espoused by the union, or if it is not espoused by the majority of the workers, then it is not a dispute at all. So the courts have no power to take that dispute to the adjudication. But now they have given a route of grievance redressal committee, where any individual dispute can be taken to grievance redressal committee, and then it can travel to conciliation and then to the adjudication. So that has been brought to them, which is not so good. And we talked about additional 15 days wages as reskilling fund. And also today, if you look at when there is any misconduct you are required to follow the principles of natural justice, and you are required to conduct a domestic inquiry. Now, there is no time limit at the moment, though Supreme Court in one of the case talks about outer and inner limits, but officially or the statutory doesn't give anything. Now, the time limit has come to complete the domestic inquiry is within 90 days ordinarily. Since the word ordinarily is used, it is not so mandatory. Not that every case you have to complete it, but there is some guideline is available. And similarly, like strike is impossible, lockout is also impossible. And then another one is facilities for the trade union at the establishment. It could be stationery, office, phone. So that have come. How far the government will enforce that, it is also important. In the latest Karnataka industrial code rules, I have not seen anything. But if there are any rules are prescribed, you may have to provide certain facilities to the union. So that is important. And we know the contract employees in case of now also today, if you look at the industrial jurisprudence, especially in industrial dispute act, the principal employer is not responsible unless it is prohibited or the contract is sham or you have certain violations. So the real employer is the contractor. With the contractor, the employer and employee relationship exists. So therefore, principal employee is not required to do anything. So it is the business of the contractor. He will take care of it. That is the stand of the code. But what you see in IR code is the employer definition is defined as the employer, and also the contractor is included as employer. So therefore, in case of contract employees, there will be two employers. So in case of the contractor fails in case of contract employees, under IR code is not able to give compensation to the contract labor, then the principal employer will be responsible. That is why the employer definition is introduced in the code. So that is, you have to keep it in mind. And also trade union disputes. Now these disputes are between trade unions, between workers. Now they have a possibility to take it to the court. And a proportionate representation of women workers in grievance redressal committee. So it was not very clear in the earlier law. Now they have made it. If there are women employees, there should be a proportionate representation of women workers in grievance redressal committee. And we talked about individual dispute litigating it. That is there in their bucket. And no requirement of minimum 7 members for registration of trade union. So this is important to understand. So earlier if you look at Trade Union Act 1926, you have 10% of the members as your members, 7 members, whichever is more. Though court talks about these two conditions have to be there while framing the union, but at the time of registration, the 7 members are not required. So that means only 10% of the members are required. For small industry, for example, if you have 50 employees, 10% is 5 employees. So even if you have 5 employees, the trade union can be formulated. Okay, so that is there. And recognition of trade unions at the central and state levels, so they can be represented like that. Next month kogappa. So code on wages, ಆ slide ಗೆ ಹೋಗಿ ಮುಂದೆ ಹಿಂದಿನ ಹೋಗಿ. Yeah, see, in the code on wages, it is the protection of employees and workers. There is nothing very specific for the employer gain, I would say, other than what is harmonization they have done, common to the codes. Other than that, in the code on wages, I don't see anything which is beneficial. Rather, it is detrimental to the employers, I would say. Yeah, 2 days payment is coming there. And also importantly, I will explain one more important provision, which also when I was in one of the ministry program, the honorable secretary was saying, no, it is not like that. There is no such provision. But then I tried to speak to her and told the provision. Then the honorable secretary told, okay, we will get into one-to-one discussion. So therefore, the provision is there. So that has to be done. So if you look at what employees have gained, one is coverage of unorganized workers and also organized sector, including managers and employers. If you look at today, the Minimum Wages Act the Minimum Wages Act, I would say, that is not applicable to supervisors and managers. They can't fix the minimum wages. But now the court talks about only employees, not the workers. They can fix the minimum wages for all the employees. And if you don't pay your wages for your manager or supervisor, they can take the resort of the code and go for a claim with authority. That is possible. Your manager also can go under the code. So that provision has been brought. And we talked about this 50% of total remuneration as base wages or inclusion wages, we said. And now basic salary cannot be less than minimum wages notified by the government. So today what you have situation under Minimum Wage Act 1946, if your gross is matching or more than the minimum wages fixed, you don't have to adhere as basic and DA. If only the gross is important, as per air freight case, that is the shelter, we can take it and you can say that that is possible. But since in the code, basic and DA is very specifically included, the government may say that whatever we fix as basic and DA, you have to conclude, you have to at least keep it basic and DA. Okay, of course you can make it more, but you can so there is a possibility that you have to stick to your basic and DA as minimum wages. Now there is another important provision in Namaste. There is another important provision in Code on Wages, which is increasing gender diversity in private establishment. So gender diversity is nothing but increasing women employees in the establishment. Under Code on Wages, they have a provision where the government can give you a direction for private establishment to increase the women manpower. Okay, of course they have to follow the principles of natural justice. They have to give an opportunity of being heard, and then with that they can also give a direction for private establishment. So then the next one is direct prosecution by the employees and trade unions in case of violations of the provisions by the employer. So no requirement of previous permission of the government. So today what is happening, if the inspector want to prosecute any establishment or the employer, so they have to give a first notice and then they have to seek a permission of the government. But under Code on Wages 2019, there is no such requirement. The employee, including your manager, supervisor, worker, your trade union, can directly go before the court if you have violated the provisions and prosecute you and run their case in the court of law. That is what the provision has come. This is, I think, I would also suggest FKCCI to take it up this matter for proper amendment. And otherwise, this everybody will file a case under the Code on Wages. Yeah, every worker will go to the court. So that is one important provision, and possibility of making principal employer responsible for payment of dues. Now let me also very clearly explain you today. Under CLRA 1970, under section 21(4) of the Act, if the contractor fails to pay the wages, then the principal employer is responsible. It is only the wages. Okay. Because the wage definition under CLRA 1970 links to Payment of Wages Act, and under Payment of Wages Act, bonus and gratuity are not wages. Of course, judiciary has contradiction on this. Some high courts have held that the principal employer is still responsible for gratuity and bonus, but largely, even including our high court, they say that the principal employer is not responsible. But on a moral ground and practical ground, you have to take care of it, because the contractor is only works for his commission or the percentage of his administrative charges. So if he has to pay gratuity and bonus, where will we bring the money? So therefore, logically, it's a responsibility of the principal employer, if I say on a moral ground and also practically. But judiciary have very clearly held that bonus and gratuity is not the principal employer responsibility. So, but today, if you talk about the Code on Wages 2019, under section 43 especially, and also employer definition, if the contractor fails, then the principal employer will be immediately responsible because of these provisions, including bonus and wages under the code. So that has come. And next one is national floor wages. You must have heard. Now the central government will fix the national floor wages. Earlier they were talking about one nation, one wage, but now I think they are talking about regional levels, wages. So once these wages are fixed, the state government or the appropriate government, which is the jurisdiction, they can't fix less than that. So as I heard, when the codes were notified, they were talking about 18,000 as floor wages, but now I think they are talking about around 20,000. So that could come possibly. Okay, that could also hit you. That's one. And we talked about wages to be cleared within 2 working days. So these are the things which employees have gained from the code. Munde hogapa. Now let's look at code on social security. Next hogapa. Yes. Let's look at Code on Social Security 2020, what employers have gained. Now, if you look at building says, today there are possibilities that the labor officer comes directly to you and talks about any construction has happened, then he will give a notice for assessment, all those things happens. But also when you are getting your plans and other things done, there is a collection at source. When they are collecting at source, normally there is a collection charges. But the courts have given you a self-assessment possibility. In case if you make a self-assessment, there is no collection charges applied. That is one provision. And if you look at EPF miscellaneous provisions and PF and miscellaneous provisions act, if you want to go for an appeal, there is a 75% of the claim amount has to be paid, but now that has been made to 25%. But it is also true that the courts now are accepting the bank guarantees based on the judicial trend, so that is also possible. That is one of the important measure for the employers. And in case of creche, of course, under Maternity Benefit Act, if you have 50 or more employees, you are required to provide creche for the welfare of women employees to take care of their kids below the age of 6 years. So that possibility is there. Same thing has been carried forward, but only one clarity is that 50 employees, whether women workers or all workers. But if I go under the Maternity Benefit Act, considering the provisions, I would say 50 women employees. But under the code, since women is defined, employee is defined separately, I would say the understanding will come as overall total employees. But the government is trying to make some correction in the rules. In the draft rules, if you see, they talk about 50 women employees. But if the same thing comes, then fine. If not, even if you have one woman employee, you may have to, you should have a creche. That's one possibility will come. And limitation for recovery of dues, I said in ESI there is a limitation of recovery of 5 years. Beyond 5 years they cannot go. But in Provident Fund, the Provident Fund Commissioner is here. You would agree with me also. They could go also beyond 5 years, and they also can reopen the assessments which have been done. But these possibilities are now closed. There are nothing. There's a clear-cut limitation, not only for ESI and PF, for any other scheme which gets framed under the Code on Social Security. There are possibilities, there are limitations are there, and even assessment case within 5 years they can't reopen. So that is also provision is there. And since under this code there are a lot of schemes, welfare schemes are getting notified. If you have a CSR outlay as an establishment, you have to pay. If you pay to these schemes, then your liability is discharged. So that provision has been brought. And now this importantly, what you have to understand is, if you look at Social Security Code, it takes a lot of statutes. For example, maternity benefit, gratuity, PF, ESI, even building says everything. But now if you look at currently there are two governments. One is central government and the state government. Only central government, wherever they have controlling stakes or public sector industries, central government is appropriate government, they will follow the central rules. But in the Code on Social Security, under appropriate government definition, if you have establishment or branches in more than one state, the central government is appropriate government. So in that case, you will have to follow the rules of the central government. So you will have a uniformity in that. Okay, so earlier you had different confusion. You had state government, different rules. If you have multiple state establishments, then you have to follow different rules. Your compliances are more. But now, since under the Code on Social Security, it is only the central government for all the purpose of the code, you will have to follow the central government rules. All the forms and everything will come. State government has no role other than the execution, but the rules and formats, everything will be central government. So this is an important measure in the uniformity of the codes. Yeah. We had something in gratuity, especially on other than factory, but now the same thing has been carried to also the purpose of the code. Next Raja. Okay. Now under Code on Social Security, let's see what employees have gained. Now we know wage for the purpose of the code is set at 50%. So they are going to get more gratuity, rather I would say. But however, this PF and ESI may not change because of the ceiling. But however, if you look at employee definition under Code on Social Security, there is one proviso which talks about, which actually excludes wage ceiling in the case of EPF. It is available for EDLI and EPS, but it is intelligently excluded for the PF case. Something will come. He's here, he may throw a light. Okay, but I only have read the law and understood. But for the PF, something will come. I don't know. They may say that there is no wage ceiling for PF. That is also possible, they say. And if you look at also, let me tell you that while notifying the implementation of Code on Social Security, EPF Act is not repealed. Okay, so something will come. Something is in the store. So let's see, or if the Honorable Commissioner want to say something, he can share. That is also possible. And additional protection to ISMWs. Now, these ISMWs are nothing but interstate migrant workers. If you employ people from outside the state here, Then currently there are certain compliance requirements, and also you have to take a license also if you have 5 or more employees. Now the code is talking about 10 or more employees, but the compliance in this case was only when you hire through contractor in the ASMW Act. But now even if you hire directly any employee from outside, or he has come on his own and he is seeking for the job, so there is a, if his salary is less than 18,000 and below, so then there is something called journey allowance which you have to take care. Only if you have 18,000 and below. Yeah, this is some protection for ISMWs. And yeah. Journey allowance. See, ISMWs now requirement is if you hire through contractor, then only there is a requirement of registration, journey allowance, everything is there. But under the code, even if you hire directly from people from outside, or the ASMWs have come on their own and sought employment with you, and if their salary is less than 18,000, you have to take care of their to and fro allowances. So that requirement is there in the code. So that is the important thing. And gratuity, we know there is higher payout, but in case of this wages 50% inclusion and 50% exclusion, there is also bigger advantage for employers also. Because if you look at the same wage is applicable for maternity benefit, the same is applicable for your gratuity, and even under the industrial relations code, your so your closure compensation, your retrenchment compensation, currently you are taking everything for all these things. Okay, but now because of the thanks to wage definition, you will only take 50%. But this is going to bring lot of disputes also, because normally if you are already practicing that you are giving full wages for in this case, workers and union will not keep quiet. So this is also dispute prone. This is also with the honorable labor secretary, I took it up, but I don't know whether they have fully understood or not. But this is one way it's a good thing, and one way it is also not so good thing. So these are also there. One way it is killing you, one way it is helping you. But when it is helping you, it will also bring a lot of disputes. Okay, so that is one. And we talked about already this fixed term employees. So that will become a game changer in Indian industries. I would say, if the spirit of the code is honored by the judiciary, then we will not have permanent employments more. So we will have only contractual employments. So that is going to happen if the spirit of the code is accepted by the judiciary. And employment exchanges today, they're not doing any work, but now they will become as career centers. There will be vocational guidance for the people who are seeking the employment, and extension of ESI to hazardous occupations. In case of this ESI, there is no requirement of threshold for hazardous establishments. Even if you have one employee, you are required to cover. Otherwise, is 10 or more. Okay. And extension of ESI benefits to unorganized workers, including gig and platform workers. The schemes are talking about it, the provisions are talking about it, and something will come in the rules and the schemes. So that will also happen. So next, Yogi sir. Now let's see what employer has got in OSH code. One is deemed registration. That means if the inspector is not coming forward within the due date, so it is deemed, and auto generation of license is possible. You don't have to go to any office. So if he is not acting upon it, the provisions will be made where this auto generation of license will happen. And also, if you look at all the codes, the role of central government is more. In order to uniform the provisions, the role of central government is more, and the state government's role is narrowed down. It's because that the code wants to ensure that there is no ambiguity, there is no complexity, there is no multiplicity. So that is why the courts want to achieve this possibility. That is why the role is taken up. And possibility of single license issued by the central government for contractors who supply pan India. Now today, if you want to supply manpower in Telangana or Kerala, you have to go and take the licenses. But now you have a possibility, take one license, entire nation is possible. And now, importantly, for especially factories, in case you would like to take overtime, the Factories Act, especially Section 65, talks about permission. You have to take a permission. If you are getting the overtime done for any emergency repairs or exempted services, which the rules will provide, in that only you are able to get the overtime done without any permission. But OSH code is talking about for all the purposes, you don't have to go to overtime permission. You don't have to go to the government and take the permission. Today you have to take the permission. And today, even though Karnataka government has allowed 144 hours, but you have before getting the overtime done, you have to go to the department and take a permission, and then only you are required to do. But now the courts have done away with that. There is no requirement, and you can take the overtime done every day at least 4 hours. There is a cap: 12 hours week, 48 hours per month, and 144 hours quarterly. This is there, but for that you don't have to go to government for permission. Now, possibility to resort to 4 days week, thanks to spread over section. Spread over is talking about 12 hours in the code. So therefore, if any industry would like to resort to 4 days per week, subject to 48 hours, and then at the rest of the days you can declare holidays, and you can take 12 hours work, but subject to 48 hours. That possibility is there, but that one may not help in the factories where there is a fatigue is there more, and there is difficulty is there more. But shops and establishment, IT and ITES, how much time I have? Okay. Yeah. Okay. So let me wind it up very quickly. 5 minutes. Okay. So the factory can have now common license also, and digitization is coming up. Next one is sir. ಆಯ್ತು ಮುಗಿತಿದ್ದು last year. Okay. So the employees now appointment issue is mandatory. Annual medical checkup for employees over 45 years. 5 years is mandatory, and now earned leaves. Now today, encashment of earned leaves during the tenure of the service is not mandatory, but now it is made. If employee worker has got 30 days at the end of the year, if it is beyond 30 days, then he can demand for encashment. So that is also possible, is there. And protection, we talked about it, and there is a portability of public distribution system is also coming for construction workers, and a portion in the penalty levied on the employer, now it can be given to dependents of the deceased employee. Munde hogappa. Thank you very much. ನೋಡಿ. No, I think I've covered everything. Yeah, thanks.
And POSH.
POSH ಗೆ trainer ಇದ್ದಾರಲ್ಲ, POSH ಗೆ ಇದ್ದಾರಲ್ಲ, ನಾನೇ ಹೇಳಲ್ಲ. Okay. So you know that already Mr. PC Rao has spoken about it, about this menstrual leave. Today the Karnataka government has mandated 12 menstrual leaves for women employees. With due respect to all my women colleagues and madam also, even if I take yeah. So this is actually an executive order, I would say. Even though under the constitution the possibility is there for they to make an a direction, but any rights in my view has to be given by a statutory amendment or by enacting a law. But that law making process has not been done. They have only given executive direction. How far it will hold good in the court of law, I am doubtful. Okay. Yeah. So that is one thing. And also government has not considered various factors, like Mr. PC Rao talked about it. Today industries work for 5 days. There are many industries, and today industries give casual leave, sick leave. If you look at Factories Act, other than the Shops and Establishment Act, casual leave, sick leave is not mandatory. Only earned leave is mandatory. So if the employer is giving casual leave, sick leave, and earned leave, everything, this is another additional burden. If there is a 52 Saturdays given, that is also additional burden. I would say if the government wanted to help, they would have amended the ESI, because that is a larger portion where garment industries will get suffered. Yeah, the government. Yeah, I would say the government did it without the lawmaking process, or they don't have the power. Now let's see what the court talks about it. It's sub judice if I talk about it, so I don't want to talk much about it. Okay. Yeah. Thanks. And the POSH, the POSH Act, Prevention of Sexual Harassment Act 2013, mandates every employer who has got 10 or more employees is required to constitute an internal committee, and internal committee also should have an external member. No, every employee, 10 or more, all employees. See, the objective of the act is, even any woman comes to your establishment, she should have a protection. customer, visitor, vendor, contract employees. Because what if your employees, harass them? Okay, so that is why. And the sexual harassment cases are very sensitive. Only if they are aggravated, they will go to court. If they are not aggravated, they will face it and they will tolerate it. In order to avoid that tolerance, now the act has given that possibility, and you have to constitute internal committee. And whenever such complaints are there, you have to redress it, and you are required to make a policy of it, give awareness to the people, and also complain. There is annual return possible also. Now you know that she box portal is there, and registration of she box is more or less made mandatory. So though the statute does not talk about mandatory registration, but the government is pushing, your district officer is pushing for registration, which is good. You can also put your returns there. So if you do that, your compliance will be good. Thank you very much. Yeah. Any questions? Please, with the permission of Mr. PC Rao.
5 minutes. The 5 minute short questions.
Yeah. 5 minutes.
We'll have a lot of questions, I'm sure. My suggestion would be that we have Mr. Mihir Kumar, our PF commissioner, to first speak, and then we can then talk. So first, on behalf of FKCCI, make it very short. A very warm welcome to Sri Mihir Kumar, Regional PF Commissioner, and Mr. Anil Aniket Ambedkar, Regional Commissioner, PF Commissioner 2. A very, very warm welcome to you for joining us today in this interactive session. These are pain points for all of us from the industry, largely because we need to have a better awareness, both in terms of ESI, minimum wages, POSH, and PF, and these are the areas of things. So we have with us a large number of members who have joined us in person, and there are that many online also who have joined us. So, not taking much more time, thank you for joining us this evening, and we look forward to hearing from you. Once we hear from both of you, we'll open it out to Q&A. Before that, I have the pleasant duty to, thank you. Let's do this. Sir, can you please share this? Okay. ಈ ಕಡೆ ಬಂದ್ಬೇಡಿ. Thank you, and please go ahead. Yes.
Good evening, everyone. What we have planned is that we'll have a short presentation. The presentation mainly focuses on the Pradhan Mantri Viksit Bharat Rozgar Yojana, where the government has given certain incentives for the employers. Then we'll have a small presentation on employees enrollment scheme, which is again a scheme of the government to encourage the employers to enroll their employees under the Act. And then third, we have a short presentation on labor code also. But anyway, labor code, sir has dealt in quite detail, so we won't have that presentation. But still, with respect to labor code, if you have any questions, we'll take those questions. So Aniket will start with the presentation, and we'll go fast. With respect to POSH, I'll just add one thing, that the chairperson has to be a lady. When you constitute that committee, so chairperson has to be a lady. That you have to keep in mind. And she can be your own employee also, external also, but she has to be a lady. That is very important. Thank you. Aniket, please start.
Thank you.
You continue.
Yeah, okay, sure. Yeah, sure. Okay. Good evening, all of you. Good evening. Thank you. So I'm here to talk about the new initiatives that are being implemented through EPFO or either directly by the EPFO. As the sir has explained, the PM Vikasit Bharat Rozgar Yojana is a scheme which has been recently launched. If you can see our Honorable Prime Minister Shri Narendra Modi's speech in the recent budget, where he announced this scheme, very clearly says that the employment link incentive scheme, and the aim is to create a new job, and under this scheme the first timer will get 1 month wage from the government. And the scheme was officially launched by our Prime Minister during Independence Day speech of 15th August of this year. So it has a very important scheme which is being launched by the government of India, and EPFO is an implementing agency for this scheme. So I'll just explain in detail what this scheme actually entails, what it has in store for both the employees as well as the employers. So this is basically our Prime Minister's aim regarding youth employment and skilling package. And it has been announced in the budget of 24-25. The total budget allocated is around 2 lakh crore rupees spread over the 5 years. And the aim is to support the employment generation of around 4.1 crore. It has various schemes under it, like we can see Skill Development Mission, National Internship Scheme, and PMVBRY, that is Vikasit Bharat Rozgar Yojana, is part of this larger initiative by the government of India, which was launched on 15th August 2025. And if you can just see that this scheme also complements manufacturing mission. How it does that, I'll explain in the further slides. Now this is regarding only about PMVBRY scheme. The total outlay that government has allotted for this scheme is around 99,446 crore. So it's almost 1 lakh crore rupees. Target is to create around 3.4 crore jobs. Now the scheme will run for 2 years for all sectors. But for manufacturing sector, it will run for total of 4 years. Now the implementing agency is the EPFO. And the scheme has two parts, Part A and Part B. Part A is for the first timers, that is the employees who are joining for the first time. Part B is for the employers. So the scheme has the benefits for both the employees as well as the employers. And the scheme has already started from the 1st August 2025. That is means registration has already been started. So for all other sectors, the scheme period is 1st August 2025 till 31st July 2027. But for manufacturing sector, it is 2 more extra years that will run up to 31st July of 2029. These are the objectives that additional employment we are trying to incentivize. And it's not just about creating new employment, but to sustain it over the period of time, which will be beneficial for both the employees as well as the employers. How it scheme aims to do that I'll explain it later. But the aim is not only to create employment, but to sustain it over the period of time. That employment generation across all sector with special focus on manufacturing sector. For the employees, we are trying to say both the employability as well as the formalization of workforce, because scheme is being implemented through EPFO. That means whoever joins and gets the benefit under this scheme will be part of the social security net. That's how the formalization of workforce will happen through this scheme. And social security coverage for the entire workforce, and the increasing the financial literacy for the employees. Now, what are the benefits of the scheme? For the employees, it will be a financial support. Government will be giving a 1 month wages to the employees restricted to 15,000, which is the statutory wage limit under EPF Act. The youth in a formal workforce, as because they will be part of the social security net of the EPFO. Financial literacy skills will be developed. On the job training they will get so that their employability will increase. For the industry, it offset the cost of additional job creation, because government intends to give benefit to employers also for adding the new employees. So that's how it offset the cost of additional job creation. Then it is enhance the workforce productivity and incentivize coverage under social security. Now this is part A, details of the part A, which is specifically for the employees, that is first timers. Now what is the definition of first timers is that any employee who is joining and getting his UN created for the first time. UN is universal account number under EPFO. So any person who is joining an establishment registered with the EPFO and getting his or her UN generated will be treated as a first timer. So that is the definition of first timer. So all those first timers who are drawing gross salary which is less than or equal to 1 lakh rupees are eligible to receive the incentives under this scheme. This is not for the employer, this is only for the employees. And it is applicable to all the establishment, whether it is exempted or unexempted, but registered under EPF Act. So any employee who is drawing salary less than or equal to 1 lakh rupees First timer per annum. No, per month, per month, per month, per month. 1 lakh per month. Right?
For eligibility, it is 1 lakh rupees, but the benefit will be restricted to
15,000, which is the statutory wage limit. Yes. Gross wages. Gross wages. So this is the incentive structure. That is 1 month wages will be paid to the employees who are the first timers in 2 installment, restricted to 15,000. So first installment will be of 7,500 rupees, which will be given to that employee after completion of 6 months. That's how the scheme incentivize the sustainability of the employment, so that those employees who want to avail the benefit won't leave within 1 or 2 months. So it indirectly helps the employers also. So for first 6 months, once the ECR, that is electronic challan returns, is filed by the employer, and we see the name of that employee is there for the 6 months, the first installment will be released. And it's a direct benefit transfer scheme. It will be directly going to the Aadhaar link bank account of the employee. No employer or no any other middle person is involved here. The second installment of 7,005 rupees will be given to the employee after completion of 12 months. So after completion of 12 months, the remaining will be given. The only additional condition here is there will be a small financial literacy course which will be available to each employee in their EPFO member portal login. They have to log into that. There will be some simple questions like how to avoid cyber fraud, what is PAN, how to link others, very basic questions, because we have variety of workforce. Not everybody will be literate. So we are trying to help every person. The aim about this is just to increase the financial literacy among the workforce. So once they complete that financial literacy course, they will get the certificate, and after the completion, they will receive the remaining 7,500 rupees installment. But that installment, it will be given in some kind of saving instrument, just to incentivize the saving habit among the employees. This is just a one-time benefit. Every employee will get the benefit only once. Registration period is, as I said, is 2 years for all other sectors, but for the manufacturing sectors, it's 4 years. And payment mode, as I said, it will be given to the bank account of the employee directly, which should be Aadhaar linked. Now this is part B. This is for the employers. The benefit will be given to the employers for the additional job creation. Eligibility is all the establishment which are registered with the EPFO, whether they are exempted or whether they are unexempted. If the establishment is registered with the EPFO, they are eligible to receive these benefits. Now there is a threshold to define the additionality of the employment. If the average employee strength for last 12 months is less than 50 for any of the employer, then the requirement of additional employment is at least 2. So suppose any employer, any establishment has 45 employees on average for last 12 months, they need to add at least 2 employees to become eligible to receive the benefit. If it is more than 50, then they have to add at least 5 additional employees. So this is the eligibility criteria and threshold for the establishment. And again, they have to sustain it over the period of 6 months. Now in this scheme, they will get benefit per employee per month, but lump sum amount will be given only after 6 months, provided that the employer is sustaining that additional employment. So that condition is again coming here. An additional employee can be first timer or rejoinee also. So there is no condition of first timer to receive the benefit for the employer. Any employee who has joined, provided they are above the threshold, the employer will get the benefit. Now there is an incentive structure there. If the basic wage is less than 10,000, which might not be case in Karnataka because the minimum wage is already high, but since it's an all India scheme, the structure is like that. If the wages of that new joinee is less than 10,000, then 10% of that basic wage will be given as a benefit to the employer. Suppose somebody has joined and his or her salary is 9,000 rupees. So the employer will get 900 rupees per employee per month. If the wages are between 10,000 to 20,000, then it's a fixed benefit of rupees 2,000, again per employee per month. If the salary is more than 20,000 but up to 1 lakh rupees, so they will get the benefit of rupees 3,000 per employee per month, but provided they are sustaining it over the period of 6 months. So they have to file the ECR in time to receive this benefit. Now again, it is for 2 years for all sectors and 4 years for the manufacturing sector. Now this benefit will also be given to the establishment's bank account directly. While registering for this scheme, employer has to give the bank details. So based on that bank details, the benefits will be directly disbursed to the employer's bank account. So there is no middle person involved again. It's also DBT. Now, what are the common features between both Part A and Part B is that both the parts are applicable to the establishment who are registered with the EPFO. Then benefit will be given after every 6 months. Establishment who are registered with the EPF for more than 12 months, how that baseline will be calculated, that I'll just explain here. If the establishment is registered for more than 12 months, that is prior to 1st August 2025, then we will take the 12-month average ECR and to arrive at their employee strength, and accordingly baseline will be decided. Suppose the establishment is registered with EPFO for less than 12 months, then for whatever months they have contributed, we will take those months ka average, and that will be the baseline. Suppose there is any new establishment which is being registered after 1st August 2025, that is after the commencement of the scheme, then the baseline for them is 20. So any new establishment which is being registered, baseline is 20, and additional employment requirement is at least 2 to become eligible for the benefit. Therefore, I explain minimum 2 additional job if the baseline is less than 50, minimum 5 if it is more than 50. But it has to be sustained over a period of 6 months to receive the benefit. All the employees whose gross wages exceeds 1 lakh. This is for the Part B, how that additionality will be calculated. Now, condition is employees should have salary less than equal to 1 lakh rupees per month, gross salary. But to count the additional employment, that limit is not there. Suppose any establishment is there which requires to add 5 employees to become eligible for the benefit. Out of those 5, 2 are having salary more than 1 lakh. 3 are having salary less than 1 lakh. But that establishment will become eligible under this scheme because they have added 5 employees. But benefit will be disbursed only for those 3 employees who are having salary less than 1 lakh. So to count the additionality, that wage limit constraint is not there. But to give the benefits, it will be treated only for those employees who are drawing salary less than 1 lakh rupees. This first timer definition I already explained, those people whose UAN, that is universal account number, is being generated for the first time. And compliance requirement, as I said, employer has to have submit the GST, PAN link bank account details to receive the benefit, and employee has to have an UN and Aadhaar link bank account to receive the benefits. This is some international experience which government has relied upon to launch this scheme. And you can see it is across the world. Singapore, Malaysia, that is South Korea, Germany, Australia. Throughout the world, we have seen wherever such kind of incentive scheme has been deployed by the government, the unemployment rate has decreased. So we are trying to achieve through this scheme also. So it is based on the international experience. Now, how to avail the benefit? For the employees, the requirement is very simple. First, they need to have their universal account number, and they need to have their bank account which is linked with the Aadhaar, so that they can receive the benefit. Only additional requirement is to complete that financial literacy course to receive the second installment of the benefit. For the employer, this is the page which will be available in employer's portal on EPFO, where registration for PMEWR, where if they click on that link, this registration page will open. Very basic information they need to fill. Once they fill it and submit, the establishment will automatically get registered to receive the benefit. This was regarding the new scheme about Vikasit Bharat Rozgar Yojana. Now, this is a new campaign, that is employee enrollment campaign, which has been launched by the government, by the EPFO, by the Ministry of Labour and Employment. The objective of this campaign is voluntary compliance. Now, this campaign is for those establishment or those employer who have not enrolled their employees despite them being eligible for the EPF. So we are coming with the scheme called for voluntary compliance. So it facilitates the voluntary compliance by the employers. It will help the employers to regularize their past defaults. And once they start enrolling those people, obviously the social security coverage will be broadened. Now, these are the important provisions. The scheme has commenced from 1st November 2025, that is this month only, and it will run up to 31st April 2026. Now, who are the employees who can be enrolled under these schemes are those left out employees who joined from 1st July 2017 till 31st October 2025. So for during this period, if somebody has joined and that person was eligible to be enrolled under EPF Act, but employer somehow missed it, then those employer can declare those employees and get them enrolled into this scheme. It's a voluntary declaration to regularize the past compliance, but it's applicable only to Indian employees. So any international worker, if it is working, that international worker is not eligible to be enrolled under this campaign. The employer will not get any benefit for the international workers. So it is only applicable for Indian employees. What are the other provisions? So all establishment, irrespective of whether they are covered under EPF Act or not, the campaign, they can take use of this campaign. So if any of the establishment which was supposed to be covered but they have not taken the coverage under EPF Act, now we are giving a chance for them to declare their employment, declare their employee strength and get covered under this, so that they can be benefited under this campaign. There will be an online declaration through EPFO portal, that is employer portal. Every employer will have their login. They will have to log in and declare the employees accordingly. They have to generate the UN through face authentication technology, that is FAT. And there cannot be any multiple declarations. Whatever employees are there, which any employer wants to declare, there has to be a single declaration in which that employer should declare all those employees. Now, what are the benefits to the employer under this? So first one is waiver of employee share. Suppose in normal course of action, we find out that one particular establishment has defaulted to enroll the employees. What action we take? We start an assessment inquiry under Section 7 of the EPF Act. In that act, suppose I am conducting the inquiry now, but for the past default, the responsibility of employee share also lies with the employer. If they do it in regular course, they will deduct from the employee's salary. But if they have defaulted, then that liability comes to the employer. But under this campaign, if they declare those employees without inquiry, then that employee share which will recover from the employer is waived off. That is a very important benefit for the employer if they take use of this campaign. Now, second is what will the employer liability? It will only be liable to deposit own share plus interest, because belated remittance is there, and plus administrative charges. So only these three liability will come to the employer. Now again, as I said, if in normal course if we assess some amount for the default, we'll recover the amount. Suppose the default pertains to period of say 17, 18, 19, 20. Payment will be recovered now after the delay of 7 to 8 years. Now in normal course, we will impose the interest as well as penalty. If the employer takes use of this campaign and declare employees now, they will only have to pay the interest amount. Damages is only minimal of 100 rupees. If many of people would have known, if this much delay is there, damages will be as equal to as the dues, because so much delay is there. Now that burden government is taking out, and minimum of only 100 rupees they will have to pay. So employer liability is only his own share, interest, administrative charges, and minimal 100 rupees of the damages. Now there won't be any suo motu action. Suppose there are some employees who have left. There were suppose 10 employees who had joined that particular establishment between this period of July 17 till October 25. Now only 5 people are there. So employer is required to declare only those 5 people. And in this process, even if we find out you had 10 employees earlier, we won't be taking any action for the remaining 5 employees who have already left. So we will be solely basing it on the employer's declaration. Okay, now 5 people are there. Benefit will be given to only to those 5 people. And as I explained earlier regarding that VBRY scheme, now any declaration made under EEC campaign, if those new employees are getting added, even that is eligible to receive benefit under VBRY. So apart from some basic benefits which I explained earlier, which the employer will get under normal EEC campaign, they can also avail the benefit under VBRY. So overall, it's a very beneficial scheme for the employers. And suppose already, as I said, normal course we generally start the inquiry to assess the dues. If already inquiry is going on, either for assessment or for the recovery, even during that inquiry period, employer can come forward now and say, I want to declare and take the benefit under this scheme. So even that is eligible for them. So those employers who are already facing inquiries, they can also participate and voluntarily declare the defaulted employees, and they can make the payment. These are some important links like notification, some FAQs, and our office has released a press release which was given. We have sent mail to FKCCI on 10th 11/2025. All these documents are available there. We request you to please share this with all your members
We'll
so that
put it up on our website.
yes. Thank you very much. Yeah. Sorry. Yeah. We have already shared that.
So
we have
what
already
I
shared.
said is we'll put this up on our website so that anybody can actually access. Yeah.
Yes. So that's it from our side. Thank you.
I'll just add that this employees enrollment campaign is a statutory scheme. It has been notified by the government. So whatever declaration is made under the scheme, you have a statutory protection. So generally there is a hesitance from the employer side that how to say admit or declare a default of a past period. So I just want to use this platform and this forum to assure you that this is a statutory scheme, and any declaration which is made by the companies, you have a statutory protection. Now I welcome all of you for any questions you have under the scheme or both the schemes, PMVBRY and EES, or any question.
Yes, we have both Mr. Govindaraju from the new labor code and Mr. Mihir and his team for the PF. So please address your question to the concerned official, and please keep it brief. Let's do it one after another. Mr. Our past president, Mr. Shiv Shanmugam, and then thereafter you.
Thank you very much. Let me give some opening remarks as a past president. Congratulations to my president and Mr. P.C. Rao, the chairman, for doing this wonderful program, which is a necessity for today. Let's give them a very big round of applause. I think so they really deserve it. And the first question we would like to ask a gentleman about labor. Sir, our team madam said just now, Sir M. Visvesvaraya was the founder. Now, the way you were talking about the employees and employer, industrialize or perish? That is the question we have to keep asking you now. But the kind of labor stress that you are going to give on the employer, should we run the factory or should we perish?
You robotize.
That's right. So that answer has to be needed. So first and the foremost, I want to say, they have not invited the stakeholders when this laws have come. That we have to request our president to see that the stakeholders have to again ask to come and participate. The second thing I wanted to ask was this meet, because we have got so many industries, trade, service, hoteliers, so many other. I feel that the president as well as the chairman can have half a day or a one-day seminar with particular subjects on industry, trade, and all this. That will be more beneficial. It will be very helpful. Sir, I want to ask you, what is the minimum labor available in the factory for them to join in a union? I wanted that for you to answer. And when is this applicable to the states? Because this is a central one. When is it applicable to the states? Or MSE getting exempted from all those things is something that we wanted. If it is not there, we will request that is the suggestion we give. MSMಗೆ 16 ಲಾಗಳಿಗೆ ಇದನ್ನು ಜೊತೆ ಮಾಡಕ ನಮಗೆಲ್ಲ ಇದನ್ನ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರೆ ನಾವು ಏನೋ ನಡೆಸ್ಕೊಂಡು ಹೋಗ್ತೀವಿ.
So we wish.
No, we are asking the president to please put up when she wants to. ಅದು ಮಾಡಬೇಕು ಒಂದು. ಇದು ಸ್ವಲ್ಪ these are my questions, and only one question to your good self is that you said all we have to give the list of the employees. Suppose our sir was telling just now, wherever if you have got another state a unit of mine, it comes under central provision.
Under code on social security.
For you also in the EPF, suppose I have got in 3 states my units. Should I give the names of all the employees in all the states, or should I give only?
We'll maybe shall we take all 3, at least 3 people
These are
to
my
ask
questions, okay?
and then we can answer, or you want to do it one by one? Okay.
Yeah. Let me
Let
answer.
him answer this, then I'll
Thank
come to
you.
Sir, 1 minute. Let him answer to him and then we'll come to you. Yes.
Yeah. Sir, let me answer your question. First of all, the codes have tried to balance both employer and employees' rights. You talked about whether industry have to perish or sustain. If you look at how GST situation was there when it came, same situation was there. Hue and cry was there. But today, this is not the situation of GST. So everything is streamlined. There are a lot of things have happened. And I'm sure labor codes, though there are certain things are not so good for the employers, but if appropriately it is taken up with the government, some measures will come. It's only question of taking up with the government. So definitely the government doesn't want to lose the industries or doesn't want to perish. The government wants to facilitate the employers. So in trying to balance the situation, some things may have gone wrong against you. That's okay. But these things will happen and some amendments have to be happen. So that will happen. And next question is coming back to your union situation. I've told you in the industrial trade union act, minimum 7 members are necessary and 10% of the employees or whichever is higher. But in the code, though it is retained, but for registration it is only 10% is required. If you have got 50 employees, 5 employees is only required. So with 5 employees, they can make a union. So that is possible. What was your next question, sir? Yeah, with regard to MSME, there are no separate exemptions other than the thresholds applicable in case of gratuity, maternity benefit, 10 or more employees. Even OSH code and OSH and WC code, if you have 10 or more employees, it is applicable to shops and establishment also. So today you have shops and establishment separate statute in Karnataka, but OSH and WC code in the establishment definition is already talking about 10 or more employees. So therefore, S&Ds who have 10 or more employees, OSH and WC code becomes applicable. In case of S&D, only it is applicable if you have 10 and below. So that is what is clarified by the ministry also in the meeting. So that is what is the understanding. So next question, sir. Yes, it is applicable to every state, but only thing is, since the concurrent chapter, the labor matter is there under the constitution, the states have to implement it in their jurisdiction. If you know already the media, Kerala has stated that they will not implement it. But let me also tell you that under the code, central government has a provision. It can give a directions to implement. So that is also possible. But every state has to implement it.
On the PF.
For social security, if you have, say, factories in 3 states, so that way we are very flexible. It is your choice. You can register at one place as per your convenience. If you want, you can register in all the 3 places also. So that convenience is there. It's not like a factory registration where you have to get all your factory registered with a local authority. In PF, it's not like that. It's your convenience.
Yeah. I would also like to add, since the appropriate government definition in central government is similar to this one, Gratuity Act. For example, if you have multiple establishments in different states, central government is the appropriate government. In my view, PF code number should be similar for everyone. You don't have to take the subcode going ahead. Now also, because of the online, you don't have to take the subcode. Even under the same code, you can cover. But that subcode requirement also will go.
I mean, it's the convenience of the companies.
Yeah.
Can I have him to ask his question and then pass?
Yeah, my name is Prakash Chandra, consultant. We are situated, our office, the PA Bhavan Peniam. See, my problem is, this is amnesty scheme is very good. EEC, we are trying last 3-4 days to upload only the employer contribution. It will not take, website is not supporting.
I filed the declaration.
Yeah, declaration file, UN number you are taken.
Okay. So anyway, if you can share me the details, sir, I'll get it resolved.
It comes to
Help desk.
No problem. Not a problem.
No.
Some help desk for this because it could be there could be many of them.
No problem. Our officers are here. She will take details. And even if it's any other office, I'll get it resolved. I'll get it resolved.
Past President Sampath Raman.
Yeah, I just have only an observation that both the presentations have been excellent, been very educative. I thank all 3 of you for having come here and enlightened us. And some people have been asking whether all these labor codes are going to be applicable, both organized and unorganized, both the sectors. But I don't know whether there is a definition, anything in the definition as organized and unorganized is going to be applicable for everyone, I thought. Kindly clarify that.
No, the courts have brought in provision for applicability of unorganized sectors, even in the Code on Social Security, which is not traditional employment. For example, if it is a company, you have a regular employment, which is not kind of a traditional employment. For example, construction, platform workers, gig workers, these are all called as unorganized workers. If you look at provisions of Code on Social Security, for all these provisions have been brought for the protection of these people. So therefore, court takes care of the unorganized workers also.
We'd go on online. We have a few questions. Sri Talam Venkatesh, past president, to unmute himself and ask, and thereafter, I think it's Manandi Suresh. That's it, right side. I don't know.
Well, I would say that it was a beautiful presentation and a lot of information. I don't know how many of us can digest this. Basically, what I would request the president is you can have workshops for SME sector, especially as to limitations and what it could be done. It could be for the owners as well as people who are doing the, labor laws and other things. I think that will go a long way. Finally, I would feel that whether it's worthwhile to be an entrepreneur is something that bothers me, Going and taking a job and getting your monthly, this one may look a lot more simpler than being called as an entrepreneur.
Thank you, past president.
Yeah.
Who's the other person?
I just want to add.
Okay, Mr. Virendra Kamath would like to add, and then after that, President Pina Industries.
Yeah, I would like to add on our past president, Mr. Talam Venkatesh, the statement. Whichever law the government implements, we have to follow it inevitably. But with this social media daily updates coming, there'll be a lot of confusion among the employees and the employers, because they'll be more knowledgeable seeing that social media. So we'll have a very tough time for first few months. So the government has to take steps to educate the employees also, as well as the employers. And of course, we have all the rights to go to the appropriate court whenever we want. In fact, Menstrual leave, Bangalore Hotel Association has approached the High Court. After that, the government was very active to introduce the scheme for the government employees also. Thank you.
Thank you, President Pina Industries Association.
ಸರ್ ನಮಸ್ಕಾರ. ಸರ್ ಲೇಬರ್ ಕೋಡ್ ಬಗ್ಗೆ ಸರ್ ಒಂದು ಕನ್ಫ್ಯೂಸ್ ಇರೋದು, ಈಗ ಆಫ್ಟರ್ 180 days ಲೀವ್ ವಿತ್ ವೇಜಸ್, ಅರ್ಲಿಯರ್ ದ 240 days, ಬಟ್ ಇದು ವರ್ಷದಲ್ಲಿ 365 ದಿವಸ ಸರ್. 180 days ಅಲ್ಲಿ ಮಾಡಿ ಮೋರ್ ದನ್ 185 days ಲೀವ್ ಇದು ಯಾವ ತರ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ?
ಅದು ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇರೋದು ನೋಡಿ, ಮೊದಲು 240 days ಕೆಲಸ ಮಾಡಿದ್ರೆ ಎಲಿಜಿಬಿಲಿಟಿ ಬರ್ತಾ ಇತ್ತು ಫ್ಯಾಕ್ಟ್ರೀಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ. ಇವಾಗ 240 days ಎಲಿಜಿಬಿಲಿಟಿನ ತೆಗೆದ್ಬಿಟ್ಟು 180 days ಮಾಡಿದ್ದಾರೆ. ಅಂದ್ರೆ ಒಬ್ಬ ಎಂಪ್ಲಾಯಿ 180 days ಕೆಲಸ ಮಾಡಿದ್ರೆ ಅವನು ಅರ್ನ್ ಲೀವ್ಸ್ಗೆ ಎಲಿಜಿಬಲ್ ಆಗ್ತಾನೆ. ಎಷ್ಟು ಲೀವ್ ಕೊಡ್ಬೇಕು ಅನ್ನೋದು ಚೇಂಜ್ ಆಗಿಲ್ಲ. 20 ದಿವಸಕ್ಕೆ ಒಂದೇ ಲೀವ್ ಕೊಡ್ಬೇಕಾಗಿರೋದು ಅಂಡರ್ OSH ಕೋಡ್ ಸೇಮ್. ಬಟ್ ಎಲಿಜಿಬಿಲಿಟಿ ಕಂಡೀಷನ್ ಮಾತ್ರ 240 days ಇಂದ 180 days ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ರಿಮೈನಿಂಗ್ ಡೇಸು 2/3 ಇರೋದನ್ನ 1/3 ಮಾಡಿದ್ದಾರೆ. ಟೋಟಲ್ ಲೀವ್ ನಿಮಗೆ
one working day for every 20 working
ಫಾರ್ 20 days ವರ್ಕ್ ಮಾಡಿ ಒಂದು 15 ಬರುತ್ತೆ ಅನ್ಕೊಳ್ಳಿ ವರ್ಷಕ್ಕೆ.
ಅಲ್ಲ 200 more, that is more. Mr. Perumal and then you.
ಅದೇ 300 days ವರ್ಕ್ ಮಾಡಿದ್ರೆ
you have one more. Okay, please complete.
ಸರ್ ಫಿಕ್ಸೆಡ್ ಟರ್ಮ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಇವಾಗ ಆಕ್ಚುಲಿ ಪೀಣ್ಯದಲ್ಲಿ ಸಾಕಷ್ಟು ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇದೆ. ಇದು ಫಿಕ್ಸೆಡ್ ಟರ್ಮ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಆಗೋದು ಪರ್ಟಿಕ್ಯುಲರ್ ಆಗಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಪ್ರಾಜೆಕ್ಟ್ ಇದ್ದಾಗ ಬರುತ್ತೆ. ಈಗ ನಮ್ದು ರೆಗ್ಯುಲರ್ ಪ್ರೋಸೆಸ್ ಇರುತ್ತೆ, ರೆಗ್ಯುಲರ್ ಪ್ರೊಡಕ್ಷನ್.
ಅರ್ಥ ಆಯ್ತು ಹೇಳಿ, ನನ್ ಕ್ವಶನ್ ಅರ್ಥ ಆಯ್ತು. ಮೊದ್ಲು ಇವಾಗ ಜುಡಿಷಿಯಲ್ ಟ್ರೆಂಡ್ ಇದ್ದದ್ದು, ನೀವು ಯಾವುದೇ ಒಂದು ಕೆಲಸಕ್ಕೆ ಕೊನೆ ದಿನ ಇದ್ರೆ ಅವಾಗ ಫಿಕ್ಸ್ ಟರ್ಮ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ತಗೋಬಹುದು, ಪ್ರಾಜೆಕ್ಟ್ ಬೇಸ್ಡ್ ಅಥವಾ ಎನಿ ಕೆಲಸ ತಗೊಳ್ಳಿ, ಅದಕ್ಕೆ ಎಂಡ್ ಡೇಟ್ ಅಂತ ಇದ್ರೆ ಅದಕ್ಕೆ ಫಿಕ್ಸ್ ಟರ್ಮ್ ತಗೋಬೋದಿತ್ತು. ಆ ತರ ನಮ್ಗೆ ಜುಡಿಷಿಯಲ್ ಟ್ರೆಂಡ್ ಮತ್ತೆ ಕಾನೂನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು. ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 201 ಅಲ್ಲಿ ಇಂಪ್ಲೈಡ್ ಇದಿತ್ತು, ಅದರಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಇತ್ತು, ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಇರ್ಲಿಲ್ಲ. ಇವಾಗ ಕೋಡ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಫಿಕ್ಸ್ ಟರ್ಮ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಅಂದ್ರೆ ಏನು ಅಂತ ಡಿಫೈನ್ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ರಿಟ್ರೆಂಚ್ಮೆಂಟ್ ಡೆಫಿನೇಷನ್ ನ ಮಾಡಿಫೈ ಮಾಡಿ, ಅಕಸ್ಮಾತ್ ಫಿಕ್ಸ್ ಟರ್ಮ್ ಎಂಪ್ಲಾಯ್ದು ದಿನಾಂಕ ಮುಗಿದೋದ್ರೆ ಅದು ರಿಟ್ರೆಂಚ್ಮೆಂಟ್ ಅಲ್ಲ ಅಂತ ವೆರಿ ಕ್ಲಿಯರ್ ಆಗಿ ಪ್ರಾವಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಾಗೆ ಕೊಟ್ಟಾಗ ಏನಾಗುತ್ತೆ, ಜುಡಿಷಿಯರಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮಾಡ್ಕೋಬೇಕಾಗತ್ತೆ. ಮತ್ತೆ ಸ್ಪಿರಿಟ್ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಫಿಕ್ಸ್ಡ್ ಟರ್ಮ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಎಲ್ಲರಿಗೂ ಅವೈಲಬಲ್ ಇದೆ ಅಂತ ಅರ್ಥ. ಆಮೇಲೆ ಇನ್ನೊಂದು ನಿಮ್ಗೆ ಹೇಳಿದ್ನಲ್ಲ, ಕಾಂಟ್ರಾಕ್ಟ್ ಲೇಬರ್ ಕೋರ್ ಆಕ್ಟಿವಿಟೀಸ್ ನಲ್ಲಿ ಕ್ಲೋಸ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ರೆ ಇಂಡಸ್ಟ್ರಿ ಹೆಂಗ್ ನಡೆಸೋದು?
Companies run.
ಅದೇ
Big
ಕರೆಕ್ಟ್ ಅಲ್ವಾ?
companies actually run on contract labor.
ಇವಾಗ ನೀವು ಎಲ್ಲಾನು ಕಂಪನಿ ಕಡೆ ತಗೊಂಡ್ರೆ ಇಂಡಸ್ಟ್ರಿ ನಡ್ಸಕ್ಕಾಗತ್ತಾ? ಆಗಲ್ಲ. ಇವಾಗ ಕಾಂಟ್ರಾಕ್ಟ್ ಎಂಪ್ಲಾಯೀಸ್ ಬಂದ್ ಮಾಡ್ಬಿಟ್ರೆ ನೀವು ಇಂಡಸ್ಟ್ರಿ ಸಸ್ಟೇನೇ ಆಗಲ್ಲ. ಎಲ್ಲಾನು ಒಂದ್ ಕಡೆ ಓಪನ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಗೌರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಿಸ್. ಅದಕ್ಕೆ ಫಿಕ್ಸ್ ಟರ್ಮ್ ಓಪನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಾವು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ತಾ ಇದೀವಿ. ಜುಡಿಷಿಯರಿನು ಇದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳುತ್ತೆ ಅಂತ ನಾವು ಭಾವಿಸ್ತೀವಪ್ಪ.
One more.
ಇಲ್ಲ. ನೀವು ಡೈರೆಕ್ಟ್ ಆಗಿ ತಗೊಳ್ಳೋದು 3 ವರ್ಷಕ್ಕೆ 4 ವರ್ಷಕ್ಕೆ ಅಥವಾ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ತಗೊಳ್ಳೋದು. ಅವರಿಗೆ ನೀವು ಎಲ್ಲಾ ಬೆನಿಫಿಟ್ಸ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ, ಗ್ರಾಜ್ಯುಟಿ ಕೂಡ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
ಕಂಪಲ್ಸರಿ ಆನ್ಯುವಲ್ ಹೆಲ್ತ್ ಚೆಕಪ್ ಅಂತ ಒಂದು
ಇದೆ.
ಬಟ್ ಇವಾಗ 40 years ಗೆ ಸರ್ ಈಗ ESI ಇಲ್ಲದೆ ಕೂಡ ಅದರಿಂದ ಬೆನಿಫಿಟ್ ತಗೊಂಡ್ಬರ್ತಾರೆ. ಇವಾಗ ನಮಗೆ ಅದು ಎಕ್ಸ್ಟ್ರಾ ಬರ್ಡನ್ ಆಗ್ತಾ ಇದೆ.
ಹೌದು. ಇದು ಪ್ರಶ್ನೆ ಇದೆ. ಇದು ಮೇಡಮ್
Yes, I know. That even we wanted to see clarification because it is the additional burden ಆಗ್ಬಿಡುತ್ತೆ.
ಸೋಷಿಯಲ್ ಮೀಡಿಯಾದಲ್ಲಿ
ಗಾರ್ಮೆಂಟ್ ಕಂಪನೀಸ್ ಗೆಲ್ಲ ಹೆಚ್ಚು burden ಆಗುತ್ತೆ because high intensity of labor. Ashjan and most of them are around that age.
No, I agree, madam. I agree.
Okay, so we'll take clarification. Mr. Perumal and then him and then you. Let Mr. Perumal speak, please. Mic on ಮಾಡಿ.
What is the minimum number of employees you require to go under the EPF? Number one. Number two, is it mandatory
20
to go to the EPF?
Minimum number is 20. And if any establishment who has 20 and more employees, is mandatory to get cover under EPF. It is not required, but there is one more provision for voluntary coverage also. If employer and majority of the employees want to get covered, they can also get covered even if the strength is less than 20, but it's voluntary. But if it's 20 and more, then it's mandatory.
Ma'am, I'll just add here. See, now what is happening is that all the incentive scheme of the government, they're implementing through EPFO because the EPFO has a credible data of the employees. So, no, not PLI. So here I would suggest that, and I would also encourage that even if you don't have 20 employees, you should take registration, which is voluntary under EPFO, so that you as well as your employees can avail the benefits which the government has brought under say PMVBRY, like this employees enrollment. If any establishment which is, say, it was not registered, but they were supposed to register, if they register now, so they get the complete benefit, that complete waiver of the employee share. Penal damages is almost waived because it's just 100 rupees. And let me share with you, right now, whatever cases we have in the tribunal or in high court, 80% of the cases is only with respect to penal damages. So that's a very big relief for the companies. Yeah, please.
So my question is to Govindaraju, sir. So this you told EL encashment for about 30 days. Like earlier, it was one organization can carry 30 days. I think during COVID, it was amended to 45 days. One can carry up to 45 days. Now, with this respect, sir, what is that encashment? Is it like more than 45 days or more than 30 days?
You have to see different two things. If it is a factory, law says if you have 30 days, you can accumulate up to 30 days. Encashment is mandatory only at the separation of employment. Okay, it is during the tenure of the service, encashment is not mandatory. Similarly, under Shops and Establishment Act, you can accumulate up to 45 days. And even in the Shops and Establishment Act, encashment during the tenure of the service is not mandatory, whereas at the separation it is mandatory. But now what the OSH code is talking about, which is also applicable to Shops and Establishment, if any worker, here also you have to make a differentiation between employee and worker. Employee includes everyone, including manager, supervisor, everyone. But the worker does not include managers and supervisors. If the worker at the end of the year, if he is crossing 30 days EL, and if he wants to encash, he can demand for the encashment with the employer. That is the only condition has come. Even in the during the service. Okay. Earlier it was during the service, encashment was not there in the law.
After him, you had the question, sir, then you. To you, please switch on the mic.
ESI na ಹೇಳ್ದಂಗೆ
ಹಜಾರ್ಡಸ್ ಪ್ರಾಸೆಸ್ ಇದ್ರೆ ಮಾತ್ರ ನಿಮ್ದು ಕಂಪನಿ ಹಜಾರ್ಡಸ್ ಪ್ರಾಸೆಸ್ ನಡೆಸ್ತಾ ಇದ್ರೆ ಅಥವಾ ಹಜಾರ್ಡಸ್ ಮೆಟೀರಿಯಲ್ಸ್ ಏನೋ ಸ್ಟೋರ್ ಮಾಡಿ ಸೆಕ್ಷನ್ 2CB ಅಂತ ಕರಿತೀವಿ ಫ್ಯಾಕ್ಟರೀಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ, ಅದೇ ತರ ಸಿಮಿಲರ್ಲಿ OSH ಕೊಡಲು ಪ್ರಾವಿಷನ್ ಇದೆ. ಅದರಲ್ಲಿ ನೀವು ಹಜಾರ್ಡಸ್ ಪ್ರಾಸೆಸ್ ಇಂಡಸ್ಟ್ರಿ ಅಂತ ಬಂದ್ರೆ ಅವಾಗ ಒಂದ್ ಎಂಪ್ಲಾಯಿ ಇದ್ರೂ ESI ತಗೋಬೇಕು. ಇಲ್ಲದೆ ಇದ್ರೆ ನಿಮ್ಗೆ 10 ಅಥವಾ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ.
ಅಲ್ಲ, ಹಜಾರ್ಡಸ್ ಇಲ್ಲದೆ ಒಂದ್ ಎಂಪ್ಲಾಯಿ ಕೂಡ ತಗೊಳಕ್ಕಾಗಲ್ಲ.
ಹಜಾರ್ಡಸ್ ಇದ್ರೆ ಒಂದ್ ಎಂಪ್ಲಾಯಿ ಇದ್ರೂ ನೀವು ESI ತಗೋಬೇಕು.
ಅಲ್ಲ, ಇಲ್ಲದೆ
ಇದ್ರೆ ಬೇಡ. ಇಲ್ಲದೆ ಇದ್ರೆ 10 ಕ್ರಾಸ್ ಅವರ್ಗೂ ವೇಟ್ ಮಾಡ್ಬೋದು. 10 or more.
ಅದ್ರಲ್ಲಿ PF
ಹೌದೌದು. ಆಮೇಲೆ ಇನ್ನೊಂದು ಪ್ರಾವಿಷನ್ ಏನಿದೆ ಕೋಡಲ್ಲಿ ಅಂದ್ರೆ ಯು ಕ್ಯಾನ್ ಗೋ ಫಾರ್ ವಾಲಂಟರಿ ಕವರೇಜ್ ಫಾರ್ ಬೋತ್ ESI ಅಂಡ್ PF. ಸೊ ಇನ್ನೊಂದು ವಾಟ್ ಬ್ಯೂಟಿಫುಲ್ ಪ್ರಾವಿಷನ್, ಇಫ್ ಯು ಡೋಂಟ್ ಅಚೀವ್ ದ ರೆಗ್ಯುಲರ್ ಕವರೇಜ್ in 5 years, you can exit at any time voluntarily also. That provision also has been brought.
Okay. Sir, yeah, I'm from the Bangalore Hotel Association. One question for everybody to know the knowledge. What is the unclaimed amount of PF left for the employees?
Unclaimed amount of ESI left also.
Yes, PF. I'm asking for PF. And the second thing I want to ask is, I want to tell you, is it's an administrative issue which over the years you have simplified it. Withdrawal of PF for the employees. Sir, I've been noticing in my restaurant, for example, everybody wants to withdraw the amount the moment it is paid.
Correct.
So the whole idea of you giving the PF was for a social security cost. But now that is gone. It has become like an SB account for them. Government has reduced its burden. You're on one side, you're saying it's social security. On the other side, you're allowing them to withdraw the amount whenever they want. And the third thing I want to do is, why can't you reduce the administrative charges and take this out of the unclaimed money?
Good point.
I'll come to the third question first. See, administrative charges, as you may be aware, it has already been reduced from 1.1. It is now 0.5. So more than half they have already reduced.
Make it zero and take it out of that money.
I'm coming to that also. Second is that you said that they are treating the PF account like a savings bank account. So now here there are two issues. One is that like government wants to facilitate in the sense that they know that like in this age the cost of living is very high. People have a lot of responsibilities, liabilities to manage their household, take care of their children education. So the government doesn't want to restrict. There are two views even within the government. One says, as you're saying, it's for social security, don't allow withdrawals, restrict the withdrawals. But the another view says, if the employee wants, so let him withdraw. So here what we are doing is, like, we try to create awareness among the employees, and we tell them, see, what is the benefit of compounding. And even in your companies also, I'm sure that those who are at a senior level, those who are educated, they will not withdraw. They will keep their PF and they have a sufficient balance when they retire. But the young generation, because they believe in, say, like earn and burn, just earn and enjoy. So that will come over a period of time. See, it is again a cultural thing, so it cannot come overnight. So it will take some time. But again, we have to inculcate that saving spirit among the employees. And the third question, that unclaimed, the first one. So the unclaimed amount belongs to the employee. It's not that government or anybody can take it. And even now we encourage that anybody who has their unclaimed account, amount, they can come with their complete identity and take the amount back. So this amount, government system, I always say in many of my interactions, that it may be little inefficient, but it's 100% safe and secure. You tell me, even one person cannot complain that my PF money was siphoned off or misappropriated.
I completely agree with you.
So not even a one person can say
I
this.
agree with you, but what I'm trying to
with
say
complete conviction, I can tell.
See, there are now of course there is.
See, why this unclaimed is happening, I'm telling you. Not only big companies or small companies, I'm telling both the examples. Overnight, anybody who has a good experience, airport, there is one company, this Air India SATs, they do this cargo handling, ground operations of the airport. There what happens is, anybody who gets a good experience, overnight they go to Gulf country. And we have got huge and they're all very low paid employees. It's not they are very high paid. So what do we do with that? So we have even taken up with the company. They say overnight they simply vanish. Even in big IT companies, you say, they get opportunity abroad, in USA, anywhere, they simply vanish. So that is not Exactly. So simply they will vanish. So our responsibility is that whatever money has come in respect of whomsoever it is, we have to keep it safe. And as and when they come, we give them. See, recently in my office, one person, he left the job in 1997, almost 30 years now. He came now and we paid him the money with complete due diligence.
So just in
Yes, ma'am.
addition to what he said, and this is something which we all face in industry, they want to withdraw. But I think a bonus amount after every year by the PF with all your, fund that you have will help them think. And that sizable bonus it should be. Like, you keep it for 3 years, they get that additional huge bonus. Then they would retain it because you're really talking about security. And I've noticed that people, when they're leaving afterwards, they're really in trouble because today's expense, yes, they're
We have
taking
in the
care of
industry
it,
one more issue.
and we have this issue.
We have one more issue in the industry. What happens to us is our employees tell us that you don't give it to the government, give the money to me. Now, this is the problem. This is the problem. That is why now, the moment I remit the money, they're going to withdraw.
See, this is the law of the land. Not tomorrow, if given a choice, I will say I won't pay tax to the government for such a bad road. So same thing applies here. So that is same thing applies here also.
Give them the bonus, sir.
That is a very good input.
Right.
Very
Yeah,
good input.
please.
Yeah, this is for Mr. Govindaraj for the labor codes. So states, right? Who mentioned that they have business in different states. So primarily the central regulations come to picture and state can only implement and so we have in state, if you know that there are certain restricted regulatory forms to be filled on a month-on-month basis, maintained and all those things. SND is a state act, as you know, and the other state, the Form T and other things will come in. So what happens in this kind of situation? So today what is happening is that whatever is the state act, everybody is following them. So has the central act rules have been rolled out? I don't think so.
Yeah.
So how do we implement this?
Let me explain to you. Under especially OSH and WC code, if you look at establishment definition, if 10 or more employees are there, then it is applicable to all establishments also. If you are covered under OSH code, then you will not get covered under S&D Act. So that is a clear interpretation because of Article 254 of the Constitution. Okay, so that act, S&D Act for you will become obsolete. It's not applicable. Only S&D Act is applicable for employers who have less than 10 employees. Yeah. So therefore, you don't have to mandatorily comply the S&D Act if you have 10 or more employees.
So just to add to what he said, sorry.
Yeah.
When we have to tell all the three states, we have got more than 10 or 50 or 60.
Yeah.
Should we take everyone into account, sir? Because
all your employees are covered. Even if you have 600 everywhere, you have to cover everyone. Yes. There's no escape on that.
And Madam, only one small, it's for everyone. I forgot to ask you, sir, gratuity 1 year ಅಂತ ಇವಾಗ ನೀವು ಹೇಳಿದ್ರು. ಮುಂಚೆ ಇದ್ದಿದ್ದು 4 ವರ್ಷದ 5 ವರ್ಷ. You said 1 year. Now a person is there for the last 2.5 years. Just imagine. And now where does he belong?
ಅಲ್ಲ ಅದೇ ರಾಂಗ್ ನೋಷನ್ ಸೋಷಿಯಲ್ ಮೀಡಿಯಾದಲ್ಲಿ ಹೇಳ್ತಾ ಇದಾರೆ 1 ವರ್ಷ ಗ್ರಾಜ್ಯುಟಿ ಬರುತ್ತೆ ಅಂತ. ಅದೇನಾಗುತ್ತೆ 1 ವರ್ಷಕ್ಕೆ ಗ್ರಾಜ್ಯುಟಿ ಬರಲ್ಲ. ರೆಗ್ಯುಲರ್ ಎಂಪ್ಲಾಯೀಸ್ ಇದ್ರೆ ಅವ್ರಿಗೆ ಗ್ರಾಜ್ಯುಟಿ 1 ವರ್ಷಕ್ಕೆ ಅಥವಾ 2 ವರ್ಷಕ್ಕೆ ಬಿಟ್ರೆ ಬರಲ್ಲ. ಅವ್ರು 5 ವರ್ಷ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಲೇಬೇಕು. ಗ್ರಾಜ್ಯುಟಿ ಯಾವಾಗ ಪ್ರೋರಾಟ ಬರುತ್ತೆ ಅಂದ್ರೆ ನೀವು ಫಿಕ್ಸ್ ಟರ್ಮ್ ಎಂಪ್ಲಾಯೀಸ್ ನ 1-2 ವರ್ಷಕ್ಕೋ 3 ವರ್ಷಕ್ಕೋ ತಗೊಂಡ್ರೆ ಅವ್ರು ಬಿಟ್ಟಾಗ ಪ್ರೋರಾಟ ಗ್ರಾಜ್ಯುಟಿ ಕೊಡ್ಬೇಕು ಅಂತ ರೂಲ್ ಹೇಳತ್ತೆ.
Last question. Anyone else? Oh, here. Sorry. Okay. After him then. Finish, please.
Yeah, overall, it was a very nice presentation and it was kind of enlightening all of us. My couple of questions are there for Mr. Govindaraj and one question for the PF. You mentioned about the PF ceiling in one of your slides. I would like you to elaborate that particular thing.
It's for me?
PF ceiling, something you mentioned.
Nanga?
Yes.
Okay.
And
ಅವ್ರಗ?
No, for you only. Okay. Yeah. Second question is we employ many consultant teachers. I would like to know whether they come under the bracket of FTE. That is to you, sir. Then for the PF, I just wanted to know whether it is the right forum to ask that question. This 8.33%, which is held for the pension part, is there any commutation allowed, and why everything has to be paid through pension only? That's okay.
Let me answer the question. Let me come to your consultancy agreement. See, it depends on what the terms you have explained in the contract. Okay, if it is only a part-time where he doesn't go regularly, and then you have a consultancy agreement, then it is not covered under the statutes. It is you will raise a bill and you will get covered under GST and you will get paid. But if you are taking regular nature of work on a consulting arrangement, that violates the law. Okay, so that is where you should not do. If you are getting someone for a regular work, you should have a fixed term employment rather than consulting agreement. So that is answer for you. And the ceiling, which what I gave a clarification, or also sir can speak. Under Code on Social Security, especially employee definitionally, on the first proviso talks about the ceiling wages for ESI and PF. Ali, they have exempted PF case. That is what we don't know what is going to come. I think the commissioner will explain that.
What was the third question? I will answer. That is a very simple question. Yeah, commutation.
That is 8.3.
Presently, under this employees pension scheme, commutation is not there. So whatever pension you get a full pension. You cannot commute it. Even ROC, that return of capital, is not there now. The second question, see, in the code, it very clearly says that up to ceiling limit, only you have the pension and insurance scheme membership. For PF, they say that there is no ceiling limit. So this, if it remains as it is, it will have a huge implication. This means that whatever basic a person is earning, his PF, both employee and employer, has to come on that. So that will have a huge implication in all terms. So the rules of Social Security is being framed, which the government will be publishing very soon for public comments. So as I expect that there will be a ceiling limit for PF also, but it will be clear only once the rules are published by the government.
Exempted the PF case.
So see, even if you see the current law, current act, even in that current act also, in the act per se, there is no ceiling limit. The ceiling limit is only in the EPF scheme, which now they are in the process of framing. So once they frame, so definitely it should be there.
Now the PF statute limit is 15,000. On 15th they are paying the what it. Now the person now drawing 1 lakh, what is now the PF? We basically 50,000?
No, that's what I was explaining.
Yeah.
That there will be a ceiling limit for that, which will be clear only once the rules are means published by the government, framed and published by the government.
We have a question here, Mr. Minish. Yeah.
Hello.
Yeah, please.
Thank you.
Yeah, this is Mihir from PIA.
Yeah.
I'm handling ESA, PF, and labor and MSCFC. I have one question to Commissioner PF.
Yes.
See, unclaimed amount 8,505 crores laying with the EPF. Okay, this is unoperative, and 57.567 crores is laid with the EPF, which is unclaimed. So this both together around nearly 900 crores. Sorry, 9,000 crores. So this 9,000 crores, when see interest on incentive, you can implement it to the finance ministry.
I'll just tell you. See, in no. I think it's not 90,000 crore.
8,000.
No,
8,505
I think it is in that range only. What he's saying. No. So I'll explain. See, in PF, see, there is nothing called unclaimed, because it's the option of the employee. We cannot force anybody. I tell you many cases where there are huge so-called unclaimed amount. We have even contacted the employees. They say that's my money. I will withdraw at my will. Please don't force us. So there is nothing called unclaimed. Inoperative, the definition is, the statutory definition is that if in any PF account there is no contribution continuously for 36 months, then it becomes inoperative. But even here also, that is the, see, it's a accounted money. See, ESI or say what happens that it goes in a fund from where they give the medical facility. But in our case, it's a one-to-one accounting. It's not a, like a pooled fund from there we give any general. It's a one-to-one individual accounting is there. That money belongs to an individual. And it is up to the individual to claim it.
Do you send a reminder to those people that this money is unclaimed, sir?
See, what we do is that we, see what I tell you. See, this is a very sensitive issue. We have to be very careful, because if we become very liberal, let me tell you, there is a high chance of fraud, misappropriation. You have to understand that. And being a government institution, for us, the credibility is very important, as I said. Because unless and until we have credibility, then how do anybody will trust us? So that way, we have to be very careful with this, say, unclaimed, so-called unclaimed amount. Yeah.
Audit rules ಬಂದಿದೆ, so every industry has to get compulsory safety audit done. ಯಾವ್ದು ವರ್ಕರ್ ಕಂಡೀಷನ್ ಇಲ್ಲ, if you are a factory.
Panel protection, it's becoming a bit too much. But
Yes.
Is there any questions online? Because we'd like to close at 7 p.m. Anyone in the online who wants to ask a question, raise of hand. None. Parshuram yadu illala? Mute alla. Anybody wants, please unmute and ask. Otherwise, I think send us a mail to the Chamber of Commerce. We'll definitely have your answers, and this is not the end. This is just the beginning. There are going to be many more discussions. So I will let the Vice President do the vote. Thanks.
Thank you very much. Ellargu namaskara. Good evening. Shri Govindaraju, Consultant Labor Law and Industrial Relations on New Labor Code. Shri Mihir Kumar, Regional Provident Fund Commissioner number 1, and one more officer, Shri Aniket Ambedkar, again Regional Provident Fund Commissioner 2. Okay, Madam Uma Reddy, President FKCCI, Sairam Prasad, Vice President, Senior Vice President FKCCI, PC Rao, Chairman, Labor Law, and our Talla Venkatesh on the line. Okay, past President and Advisor of Labor Law Committee. Okay, past Presidents and Managing Committee members, members of the Association, members of District Coordination Committee, and members of the Labor Law Committee, and President and office bearers of different associations. I also welcome the who present on the Zoom. Almost 99 people, more than 99 people were there in the Zoom. Good, it's really good, this thing. Ladies and gentlemen, on behalf of FKCCI, I wish profoundly thanks Shri Govindaraju as Consultant, Labor Law and Industrial Relation, and Shri Mihir Kumar, Regional Provident Fund Commissioner 1, and our Aniket Ambedkar, Regional Provident Commissioner 2, for gracing today's interactive meeting. In spite of their busy schedule, they have made it convenient to participate and give their valuable update to the members on presenting issue related to new 4 labor codes and employees provident fund, especially new benefits. I hope today's interactive section was good, has been much help to our members, as we need to comply with these rules of the government. As Mr. Govindaraj mentioned, we are also going to make some what are the objections, what are the need from our association, as our president told. I also thank Shri PC Rao, Chairman Labor Law Committee, for taking this initiative and conducting interactive meeting. I also thank our Shri Talla Venkatesh, past President and Advisor of Labor Law Committee, for giving valuable inputs and advice in conducting this interactive meeting. I thank President for all the support given for this interactive meeting. I also thank all the members, both who are present physically as well as virtual. And finally, I thank the Secretariat for effectively organizing this important interactive meeting. Thank you, one and all.
Good, sir.
He had some problem, na? When I wanted to just take the details, I think he's left. One guy was here, na? He had some error.
ಯಾರೋ ಒಬ್ರು ಏನೋ ಮಾತಾಡ್ಬೇಕು ಅಂದ್ರಲ್ಲ ಯಾರವರು PF
He was facing some error.
ಇಲ್ವಾ somebody wants to talk. Okay, he left it. ಬನ್ನಿ ಬನ್ನಿ.
I'm Guru, small percentage.
Yeah, yeah.
My sister has got EPF here.
Okay.
She was worked.